In today's video, we're going to look at the case of the trust of Eva Marie Hanson. My name's Gregory Singleton. I'm an estate planning and probate attorney with Signature Law. Signature Law is an estate planning and probate law firm that serves the Twin Cities and Greater Minnesota alike. Just a reminder, if you like today's video, please feel free to hit that like and subscribe button. It really helps support the channel. We just recently hit 100 subscribers, so we're on our way to 1 million. A couple caveats before we get going. First of all, these videos are for educational purposes only, not giving legal advice. Second of all, we are specifically going to be talking about Minnesota law. The law may be completely different in other jurisdictions, so make sure you talk to a practitioner in your jurisdiction before you go to plan your estate. All right, the trust of Eva Marie Hanson. This was a revocable living trust, and generally with a revocable living trust, the settlor, the person who creates the trust, has the right to amend or revoke the trust at will during their lifetime. The question is, are there other people that have the power to amend or revoke the trust? Sometimes a successor trustee can do it. Sometimes a person under a durable power of attorney, acting as the attorney in fact, can do it. Sometimes a trust can be written so that either of those two people can do it only with court approval. That's another option. There's a lot of flexibility here. In this case, the question is, can somebody using a statutory short form power of attorney amend a revocable living trust when the trustee is incapacitated? Let's go over the facts of the case. They're a little bit long and convoluted, but I'll try to keep it clear. First of all, the Eva Marie Trust was drafted in 1995. In 2012, Randy, her son, Eva Marie had two children, Sherry and Randy. Randy was severely disabled in an automobile accident and started receiving SSDI. SSDI is a governmental benefit for which you have to qualify by having a decreased amount of assets. There were also on Randy's side some marriages and remarriages, not necessarily important here. In 2013, Eva Marie amended her trust to change the distribution, and this is the key distribution. The trust gave everything to Randy and Sherry in equal shares, or if one of them didn't survive them, it would go to their children. Now, Randy's estate, he changed things over the years. In 2017, at Sherry's behest or request, he established or had established for him a supplemental needs trust. The beneficiaries of the supplemental needs trust, when Randy dies, would be his wife, Linda, and he disinherited his children from the supplemental needs trust. He also drafted a will in 2017, which gave everything he owned to his wife, Linda, and disinherited his children, Andrea and Aaron. Eva Marie had some mental decline, and Sherry took over as successor trustee of the Eva Marie Trust. She also was attorney in fact under a durable power of attorney, specifically the statutory short form power of attorney. In October 2018, Eva Marie dies, and based on the 2017 amendment that was done by Sherry as attorney in fact, half of all the estate went to Sherry, half of the estate went to Randy's supplemental needs trust instead of directly to Randy. In March 2019, Randy dies and his supplemental needs trust distributed out to Linda. So those are the key facts. I hope I got them all right. Now here's the procedural posture. The procedural posture is what happened in the courts. First of all, Aaron and Andrea, Randy's children, challenged the distribution that was done in 2019, arguing that the 2017 amendment to the trust was improperly done. Why was it improperly done? They said because it was done under a durable power of attorney, and this wasn't authorized. The district court disagreed with them and said, the 2017 amendment, that was fine. Andrea and Aaron did not agree with this, and they appealed up to the Minnesota Court of Appeals, which is the case that we're looking at today. The question before the Court of Appeals was it okay for Sherry to amend the Eva Marie Hanson Trust using a statutory short form durable power of attorney? Now, Sherry's argument was under Minnesota statute 501c 0602E, subdivision E, a settlor's powers with respect to revocation, amendment, or distribution of a trust property may be exercised by an agent under a power of attorney only to the extent expressly authorized by the terms of the trust or the power. Now, the court said before we even get to subdivision E, we looked at subdivision C1, which says amendment must be by substantial compliance with a method provided in the terms of the trust. Now, the trust language said the right to amend was personal to Eva Marie and absolute, meaning that nobody could amend the trust other than Eva Marie. The court said, based on the language within the four corners of the trust, that's what we have to follow. And the amendment to the trust in 2017 under the statutory short form power of attorney was incorrect. Now, I agree with this conclusion. If you want to have somebody be able to amend your trust, you need to amend the trust or write the trust so that they have that right as an enumerated power. I think the court was a little bit sloppy and got a few things incorrect, and I just want to point them out because this is an educational video and it's good to look at. First of all, the amendment was done under a statutory short form power of attorney. The question is, why do we even look to the trust if that power is not in the statutory short form power of attorney list of powers? Now, on the screen, you see the various powers. There's 13 enumerated powers that are authorized under a statutory short form power of attorney. Note that none of them say the right and power to amend a revocable living trust. Now, I've had some discussions with colleagues, and some have said that fiduciary transactions authorizes someone to amend a revocable living trust. Others disagree. I'm in the camp that disagrees and said fiduciary transactions is not amending a revocable living trust. If you want to amend the revocable living trust, it has to be specifically enumerated. So my take on it is, no matter what the trust said, the statutory short form power of attorney didn't even authorize that power to Sherry to do the amendment in the first place. Therefore, it's void on its face. The second problem, and this is going to what was not included in the decision, is why did we, well, first of all, let's go to why we amended the trust. Now, the trust was amended so that it would distribute directly to Randy's supplemental needs trust and not outright to Randy. If it went outright to Randy, he might be kicked off SSDI or not qualify for it. Therefore, that was a proper amendment. It doesn't seem to be malicious. Now, I will say this is another area where the court got wrong. The court said that Randy created a special needs trust, and that's patently wrong. You can't create a special needs trust for or a supplemental needs trust. The court said Randy created a supplemental needs trust. You cannot create a supplemental needs trust for yourself. You can only create a special needs trust for yourself. So I'm guessing Sherry's the one that created the supplemental needs trust, but that's less important to the case. Now, here's the big place where the court is lacking in their decision. Under the 2013 distribution plan, as was amended by Eva Marie, everything goes to Randy if Randy survives Eva Marie, and then then it would be distributed under Randy's will. No one contests that the will was properly made. So essentially, it would go to Randy and then go to his wife, Linda, as long as Randy survives Eva Marie. Under the 2017 plan, everything goes to Randy's supplemental needs trust and then goes to his wife. Now, this is why we know it's a supplemental needs trust, because if it was a special needs trust, it would have to go to the government and not to his wife. So if you look at the 2013, it goes to Randy and then to his wife and not the kids. They're disinherited. Under the 2017 provision, it goes to Randy's supplemental needs trust and then to his wife. The kids are disinherited. So that raises the big question. Why would his kids protest the 2017 distribution? Because under the 2017, if they win and get rid of the 2017, then they have to rely on the 2013 distribution. They still get nothing. So they're wasting a lot of money contesting this distribution. I couldn't figure it out. My colleagues couldn't figure it out. I actually called Kimberly Prashal, the attorney who argued on behalf of Andrea and Aaron, and asked her, why the heck did they even take the case? First of all, Kimberly, thank you for taking my call. I really appreciate it. I didn't want to take up too much of your time, but thank you for taking the time to talk to me. Second of all, the answer is that the trust terms said that in the 2013, that if one of Eva Marie's children is on has under a legal form of disability and therefore getting benefits, they become disinherited and it just goes to the next person in line. And in that case, it would go to Randy's kids. The court did not include this, and I think it's a key fact. Otherwise, we don't have a case at all. So, a little sloppy. Whatever. My apologies to whatever law clerk wrote the case, but there's a few things lacking in this order. So, that's my take on the estate or the trust of the Eva Marie Hanson Trust of 1995. I hope you liked today's video. If you did like today's video, please feel free to like and subscribe. Again, really helps support the channel. We do a new video every other Wednesday. If you have any questions, leave them in the comments below. Otherwise, until next time, this is Gregory Singleton with Signature Law.